welcoming you all to AML UAE's yet another insightful session on the anti-money laundering compliance. As you are well aware of the importance of CDD process in combating the financial crimes, one of the key elements of this process is customer name screening. Today, we will discuss this essential AML compliance process and the best practices for optimizing your screening efforts. To take us through the screening requirements, we have an AML expert professional with us today, Ms. Dipali Vora. As you know, she is a qualified company secretary with 8+ years of experience in overall corporate compliance, including anti-money laundering. Her knowledge and hands-on experience on the subject makes her sessions interesting and informative. Her personalized AML training has already positively impacted the lives of more than 1,000 compliance professionals. One more thing during the session, if you have any questions on the topic, feel free to post in the chat or the Q&A section. This webinar will be recorded and will be uploaded on our YouTube channel. So have a good learning and over to you, Dipali.
Thank you so much, Jyoti, for the wonderful introduction. So today we all have gathered here to understand what exactly screening is. So before I jump onto the topic, let's first set the background of the rules and regulations which are prevalent in UAE. So if I talk about the AML regulatory framework in UAE, we have federal law, cabinet decisions which are issued by the authorities in order to help us comply with the regulations. Federal Decree Law number 20 of 2018 talks about anti-money laundering and combating of financing of terrorism with respect to all of the illegal organizations, individuals. Cabinet decision number 10 of 2019, also regarded as the implementation regulation, will help us to comply with what all is written in the Federal Decree Law number 20. Now, we also have Cabinet Regulation number 74, which talks about terrorism regulation or implementation of UN Security Council. So in this regulations, the requirement of screening, freezing measures is all given in Cabinet Resolution number 17, which we are going to briefly discuss in today's session. Apart from that, there are certain regulations which are being issued by specific authorities like ADGM, DIFC. They have their separate rule book. So the companies which are operating in ADGM and DIFC, they are required to comply with the rule book which is issued by their supervisory authority, as well as the one that is Federal Cabinet and Cabinet Resolution 74. These are the three regulations which forms, I would say, they are the base of all of the other guidelines which are issued. Apart from that, in order to help the sectors which are working in UAE, there are sector specific guidelines which are issued, like specifically for real estate sector, auditors, accountants, dealers in precious metals, also with respect to the real estate agent, then lawyers, notaries. For them, there are separate guidelines which are being issued to help them to understand what are their obligations, which could be easily be found and downloaded from the official websites. Now let's talk about what are the basic compliance requirements for the DNFPBs which are operating in UAE. The definition of DNFPB includes 5 specific industries, which is dealers in precious metals and stones, real estate agents and brokers, company and trust service providers, auditors and accountants, lawyers, and independent professionals. So these are the 5 categories of companies to which anti-money laundering and combating financing of terrorism rules and regulations apply. So there are certain obligations which all of them have to comply with. So we'll just touch down on this very briefly. First and foremost, GoML registration. So all of the companies which belong to the specific industry are required to get themselves registered on GoML portal. All of the newly incorporated company, they must simultaneously register themselves without fail on this particular GoML registration, which helps you to report certain transactions with financial intelligence unit. So at the time of GoML registration, we are required to appoint a compliance officer also, nominate a person's name who will be acting or I would say who will be the person responsible for anti-money laundering law compliances in the organization. So these are the regulatory requirements. Once you have registered with FIU, the next step is conducting enterprise-wide risk assessment, also known as firm-wide risk assessment, also known as business risk assessment. So these terms are interchangeably used. The essence of enterprise-wide risk assessment is risk-based approach. What we are required to do at this stage, that is point number 3, is we need to understand our own organization and calculate the risk that our organization is facing or is going to face for the companies who are newly incorporated. So at point number 3, we will understand what kind of customers we are dealing with, what is the risk coming from those customers. Now, if I am your customer, for example, I belong to a high risk or maybe gray list country, or I'm a politically exposed person. So there is some kind of risk which would be, which will impact your organization also. But when I say point number 3, EWRA, here we are considering the entire customer base that we have. If let's just put two organizations, one organization is only onboarding politically exposed person or high net worth individuals, the risk of that organization will be very high compared to the other such organization where they are only dealing with salaried people, or the one who are not high net worth basically, or they don't have any political background. So point number 3 emphasizes on the kind of transactions we enter into, the customers that we deal with, what nationalities they belong to, how are we onboarding our customers, how are we completing a transaction, as in how are we accepting the payments, whether cash, virtual assets, or maybe through bank transfers, checks, what exactly. So all of these factors are going to impact our company's risk. So that holistic calculation of risk is enterprise-wide risk assessment. Once we have done this, we'll be in a position to understand our own organization, where we stand in terms of risk. After that, we'll be in a position to draft our own AML CFT policies and procedures, where we will also mention about the KYC requirements, how we will file suspicious activity report, what documents we will seek for. So that all is basically mentioned in our AML CFT policy and procedures. Point number 3 and 4 is documentation, which all of the DNFPBs must have in place. Now, how are we going to practically put that thing into practice is conducting KYC. When we onboard any customer, it's our responsibility that we understand what that person is, develop an identity or get their ID documents, create a profile of that person. What all documents we will seek for, we will look at in the upcoming slide. Once you have the ID documents, you will be in a position to screen that person. Now, UAE has two mandatory sanction lists, that is UNSC consolidated list and UAE local terror lists. When you screen the customer, depending on the results that you get, there are certain compliances which are prescribed. And today we have met for this particular topic, that is screening. So we are going to, dive deep into this particular topic. So I'll just move on to the next is, after we screen, we will know what the background of that customer is, whether PEP, whether sanctioned, whether any adverse media. After this is completed, we will then be in a position to bifurcate our customer database into 3 categories. That is low risk, medium risk, or high risk. Depending on the risk category that is assigned, we will apply the due diligence process. For all of the customers who are low risk, medium risk, standard due diligence would be applied, and the one who are high risk customers. Okay. In such cases, we are required to apply enhanced due diligence. That is something additional. Enhanced word itself says we are going to do some extra due diligence for the one who are high risk. So once the enhanced due diligence is completed, we will then provide these services. In this entire process of completing the KYC, asking for the documents, providing services, billing them, if we come across any situation where we believe that that customer or that transaction was suspicious, we have the option of filing suspicious activity report or suspicious transaction report. There's also one concept called as ongoing monitoring. So once somebody is onboarded as your customer and there's a long-term association with them, we have to make sure that we are making sure that their database is updated with us. For example, I'm your customer. I'm going like you are a dealer in precious metals and stones. I'm a supplier to you. The transactions are going to be a lot. I mean, there will be multiple transactions of mine with you. So in such cases, you have to make sure that the KYC details which are there, the trade license copy, the passport details of the KYC documents that you seek for, that is updated with you. If there is any changes in the profile, then of course re-KYC should also be done. There are record keeping requirements also. That is 5 years. We are required to maintain all of the records with respect to a transaction, customer due diligence for a period of 5 years. For other zones, the requirement would also differ. Like in some zones, the requirement is 6 years. Apart from that, there are other various, compliance requirements also, like getting the AML CFT audit done, filing of certain sector-specific reports like DPMSR reports, real estate activity report for real estate agents, brokers, and lawyers. Then we have semi-annual reports. We need to prepare the semi-annual report and keep it and submit to the supervisory authority. In certain transactions that we enter into where high-risk jurisdictions are included, like North Korea, Iran, or Myanmar, we have to file a certain report called as HRC or HRCA report. That's high-risk country activity report, high-risk country transaction. Then there is mandatory AML training. So this is very important. The staff which is working in our organization needs to be trained on the AML CFT subject. So this is one of these are the basic requirements for all of the DNF PBs which are operating in UAE. So today we all have gathered to understand what is screening, what do we do in case we get full match, partial match, what is the, what do we do when there is no match, how do we proceed further, what is the timeline for filing certain reports like FFR, PNMR, what are the different aspects of screening like adverse media screening, PEP screening. So this is something that we are going to understand today. Before that, before conducting screening, it is very important that we have ID documents or some identification document with us for the customers that we onboard. So the customer onboarding process has certain elements in that. First is know your customer. That is, we ask for certain documents from the customer as well as the ultimate beneficial owners. We also seek certain information from them. Once we have this, we will then be in a position to screen their name manually or through whatever process that we are following. The next would be customer risk assessment. We bifurcate our customers into low risk, medium risk, and high risk. For the ones which are high risk, we are required to conduct enhanced due diligence. So the customer due diligence process, if once done, the next step would be ongoing monitoring. So the transactions, the customers that we are going to deal with, or the transactions that we get into, we have to make sure that we are monitoring them on a regular basis, in just to make sure that there is nothing suspicious happening in our organization. So the KYC requirement, to just briefly discuss about the documentation part, information, what we will seek from natural person and a corporate entity. So there, the documentation, if I talk about the natural persons, that is an individual, we need to have their ID proof and address proof. Now, in what is admissible as a documentary evidence for ID proof and address proof? ID, Emirates ID, passport, or driving license, or any government issued document, but that must have a photograph. That is something which would be admissible as the identification proof for an individual. For address verification, we must have utility bill, municipal tax record, property purchase or rent agreement. Bank statement will also work, insurance policy. But basically, the document should have the name of that person. The address must be written on that. If we are relying on utility bill or bank statement, we have to make sure that that is not older than 3 months. Now, coming to information. So when we seek certain identification document and address verification documents, there is quite a lot of information would already be there in the documents which are submitted. But apart from that, there are certain other information also that we need from the customer, like occupation details. What is the details of the employer? Where are they working? What is the address? So these are the information that we need to document. We have to make sure that the KYC forms that we use in our organization must be designed in such a manner to accommodate this mandatory requirements. Coming to corporate and legal entities. So the companies with whom we work, we have to make sure as a part of the identification proof, we must have their certificate of incorporation, memorandum of association, articles of association, trade license copy. Certificate of good standing is a good to have document. Now, if you are dealing with a local entity, trade license would be admissible. But if there's a company which is belonging to some other country, possibly they won't have trade license concept. So in such case, you can accept the certificate of incorporation. Memorandum and articles of association is a must-have document because that will let you know who the UBOs are, who are the person who had invested, who are the stakeholders in that company. So AOA, MOA, certificate of incorporation or trade license is a must-have document. For address verification of the company, so the utility bill, municipal tax record or bank statement, that all must be in the name of the company. That must be taken as the address verification proof for a corporate entity, company basically. When we are onboarding a company, we have to make sure that we are also asking for the details of the ultimate beneficial owner in that organization. Ultimate beneficial owner are basically those individuals who hold more than 25% of shares or have voting rights or have controlling rights in the organization. So if there are, the ultimate beneficial owners in the company, we must ask for their ID document as well as their address proof in order to complete the KYC of that particular customer. Once we have all of the KYC documents in place, KYC form, ID proof, address proof for maybe an individual or a corporate, we will then be in a position to screen them. So screening, what is exactly screening? Screening is a way in which you are comparing your customer's details, or I would say name, with the other sanction list, adverse media, or maybe you're also looking at the database of politically exposed persons. So when you screen your customer, you would come to know that whether that person is sanctioned in UNSC consolidated list or UAE local terrorist list, which are mandatory in UAE. But if you are using a software, you might get access to various other countries' sanction list also. So in such cases, you would know that a person must be sanctioned in some X country and he is traveling here. So that is how you will come to know that that person is risky, or how will that impact your organization. So in the process of name screening, we will identify, or per se I would say, we will create a profile of that particular person. We have ID documents. Now we will check various databases, independent sources, Google, to understand what this person is, what other media information is available with respect to that person. That is called as name screening. Now let's understand when will we screen them. We will be screening the customers prior to onboarding them. So if I am your customer and I'm coming for inquiry for some transaction, it is your obligation that you screen me before you onboard me as your customer. Second, if you have already onboarded me, okay, if I'm having a transaction with you again, okay, I am your regular customer, we are having regular transaction. So in such cases, screening should be done at every transaction. Now, again, if I am your customer, every company would have some policy with respect to reviewing their KYC. 6 months, 1 year, or maybe, 1.5 years, that you are going to review the profile of your customers for low risk, medium risk, or high risk. When such review is happening, if there is any change in my information, my profile has changed, maybe now my nationality has changed, or my company's name has changed. So in such cases, we have to make sure that when there are updates in my profile, screening should be done at that instance also. Fourth is when there are any updates in UNSC consolidated list or UAE local terrorist list. Now, the sanction list which are there, they are not constant. Crimes are occurring every day. The sanction lists are also getting updated. So we have to make sure that whenever there is any change in the sanction list, we are screening our customer database. To just give you an example, today, for example, there are 100 names in UAE local terrorists. Tomorrow, 5 names are added. So our responsibility would be to check that the 5 names which are added, whether their name is common in my customer database or not. So that verification should also happen within 24 hours. Now, how will you conduct screening? Screening can be done in two possible ways, manually and through the software. So when manually screenings are done, you have to go to the EOCN website, which is available, where you will find UNSC consolidated list and UAE local terrorist list to refer, where you can manually search your customer's name in this sanction list. That is how manual screening works. If you are doing it through the software, of course, this tool is would are mandatorily required to be covered. But in addition to that, you would be able to screen a lot of other sanction lists also, including adverse media, social media. So that is also something which would generally be covered in the software if you are using it. So it would be automated process. So now I would request all of the participants to scan this QR code, okay, and answer the questions which are available here on the topic that we just covered. We'll just wait for some more responses. Okay, so let me discuss this question with you. At what instances we must screen the customers? So screening is to be done prior to onboarding. Okay, once you onboard me as your customer, you have to screen me. If you are having a transaction with me again, I'm just giving an example. If you are having a transaction with me again, at that point of time, also you need to screen me. If there is any update in the UNSC consolidated list or UAE local terrorist list, still you need to screen me. So the correct answer is all of the above. The next question. Which are the mandatory sanction lists in UAE against which screening should be performed? So the correct answer is A and B, that is UNSC consolidated list and UAE local terrorist list. These are the two mandatory sanction lists against which screening must be performed. So the next topic that we are going to discuss is targeted financial sanctions. Targeted financial sanctions basically means that the sanctions which are imposed on specific individuals, organization, entities, or they are forming part of the sanction list, that is UNSC consolidated list, UAE local terrorist list. Now the main essence of implying TFS is that we will be making sure that we do not provide any financial assistance to them, and we immediately apply freezing measures. So these are the two main purpose of applying targeted financial sanctions. As I said, asset freezing without any delay. This is the implication, or this is something that we will do when TFS is being applied. Asset freezing without delay means we are making sure that we are acting as a blockage for a sanctioned individual to transfer or maybe buy an asset. And second is prohibition from making any funds or other assets available. So, I mean, the question would pop up is that we are a DNFPB. How would we have the power to freeze the funds? But to give you an example, if you are into real estate business or you are into dealing in precious metals and stones, how you can apply or how you can help in prohibiting the access of the funds is by not allowing buying or selling of the property, by not allowing buying and selling of the jewelry or any precious metals. So this is how you can contribute in prohibiting any kind of access to the funds or assets to that sanctioned individual. What are the requirements under TFS? Now, if I talk about the requirements, targeted financial sanctions, as I discussed earlier, that we have some obligation to screen the customers before we onboard. So the requirement is that we screen the customers before they are being onboarded against the mandatory sanction list. Once the screening is done, we are required to monitor them regularly also. That is, I am your customer maybe since 2 or 3 months. Now, again, there's an update in the UNSC consolidated list or UAE local terrorist list. You have to screen me again to make sure that your existing customer database, which is there, whether any name is common in the sanction list or not. So before onboarding the customer, second is after the onboarding also, if there are any updates in the sanction list, we have to make sure that we are screening them. Also, by this TFS regulations, we have the power to immediately freeze the funds as discussed. So here we do not need any permission to freeze the assets. We can immediately apply freezing measures if we come across any sanctioned individual. And this freezing is for infinite time. The unfreezing will only happen after the competent authorities instructions or when the the sanctioned person is taken out of that UAE local terrorist list or UNSC consolidated list. Only then unfreezing will happen. So these are the basic requirements under targeted financial sanctions. Screening them before onboarding. After they are onboarded also, we have to make sure that we are monitoring them. Their name should not be there in any sanction list, because if that happens, we have certain actions and certain reporting obligations which we will discuss. So as you can see currently, the DNFPBs are firstly required to get themselves subscribed to EOCN website. So the one who will try doing it might get confused with creating a login or subscribing. So it is very simple. You go to EOCN website, click on TFS implementation, and we just need to mention our company name in English and Arabic, mention the email ID and subscribe to that notification. When we subscribe to that notification, we will receive regular updates. Regular update means if there is any update on UNSC consolidated list or UAE local terrorist list, we will receive an email notification stating that maybe 4 names added, 10 names added, 6 names amended. So this kind of emails will be sent to you to make sure that you are updated with any kind of changes which are done in the sanction list. Once you receive such emails, our obligation again is to make sure that no names are matching from the sanction list with our customer database. So if that happens, what are the compliances that we need to do? Let's look at that. For all of the new inquiries that you get, okay, when you screen them, and if you get a confirmed match means if the name, date of birth, nationality matches. When you screen somebody, say XYZ, that XYZ nationality, date of birth is 100% matching, okay, then there is a possibility that this is a confirmed match. So in such cases, you have to reject the customer and apply freezing measures and file FFR report, fund freeze report on the GoML portal within 5 days. This is the obligation in case of potential new inquiries that you get. If there's any existing customer, okay, whose name is now appearing in the sanction list and it's a 100% match, in such cases, we must freeze the assets. Now, freeze the assets, as I said, the way in which we can do is make sure that we are not transacting with them. We are not providing any kind of services to them, which will aid or which will help them to fulfill their motive. So, freezing assets or and also prohibit providing any kind of services. That is the action that we need to take when we come across a situation where any of our customers is 100% matching with a sanction list. So in such cases, again, the obligation is to file fund freeze report within 5 days. So for all of the confirmed matches, confirmed means 100% match, we need to file fund freeze report within 5 days. That is with respect to existing or potential customers. For all of the partial name matches. Partial name matches means, you have screened somebody and you are in the dilemma that whether you're not able to take a decision, whether it's 100% match or it is 100% negative. Okay, in such cases, there is a possibility that a situation of partial match will arise. Partial matches means maybe the name is matching, date of birth is matching, but the nationality is not matching. Or maybe there is a slight spelling difference in the name. So in such cases, there is a possibility that it could be a partial match. Now, when there are partial matches also, we need to verify them. Okay, for example, Mr. XYZ. The name has slight difference. The nationality is matching. But if you compare the date of birth, okay, in the sanction, it says that the person is maybe 45 years old. But the person who has come to you, okay, is just a maybe 18-year-old boy who is college going. So it is very evident that it's a false match, though some of the key identifiers are matched. So we have to logically decide whether it's a false positive, what exactly. So that is how you conclude with confirmed matches and partial matches. Now, if you come across any partial matches, we have to make sure that we are suspending all of the transactions with them. You file partial name match report within 5 days. So fund freeze report is for confirmed matches. Confirmed is 100% the key identifiers are matching. For those names where the key identifiers do not match 100% and you are not sure, you're not able to take a decision, a yes or a no. In such cases, partial name match situation will arise. You have to file PNMR, that is partial name match report, within 5 days. All of the transaction must be suspended with immediate effect, and transactions can be entered with that person only after you have received certain instructions from the financial intelligence unit. For all of the persons, when you screen and you do not find any match, it's I would say it's a green flag. Go ahead, complete the risk assessment, provide services, and onward. So basically, that is how you act when you screen a person and there is no match. One thing to just keep in mind is that fund freeze report and partial name match report is to be filed only and only if the confirmed matches and partial matches are with respect to UNSC consolidated list and UAE local terrorist list. If the match type is with these two lists, only then FFR and PNMR will come into picture. Otherwise, you may opt for filing suspicious activity report or suspicious transaction. That is how you have to, like, this is what the compliance requirement is. So again, I need the responses on the topic that we just discussed. Let's have a quick quiz and We'll just wait for a few more responses and then I'll discuss the questions and answers. Okay, so I think there is some confusion with respect to fund freeze report and suspicious transaction report. So confirmed matches, as I again said, if you screen a person, say for example ABC, now that name is matching with UNSC consolidated list or UAE local terrorist list, okay, that is the mandatory sanction list. In such cases, we are required to file fund freeze report. Okay, suspicious transaction report is to be filed when when the transactions are already done and later on you come to know that maybe some transaction which was done was a suspicious one in the past. Giving it a sanctions angle, if you come across a person who is sanctioned or there is sanction evasion by any person with respect to other sanction list, like to give you an example, UK HMT or EU sanctions. So in such cases, suspicious transaction report can be filed. FFR report, that is fund freeze report, and partial name match report are exclusively for mandatory sanction list, that is UNSC consolidated list and UAE local terrorist list. So the correct answer of this question, which report is to be filed for confirmed matches with mandatory sanction list, is fund freeze report and not STR. The second question is, within how many days of identifying the sanctioned person, DNFPBs are required to file fund freeze report? So the correct answer is 5 days, 2 days, 7 days, 10 days. Nowhere for any other report this kind of timelines are mentioned. For specifically fund freeze report and partial name match report, the timeline prescribed as per the law is within 5 days. Now, so far we have understood what is sanction screening, what are the implications of sanction screening, why do we screen, what are the reports that we are required to file. Now we are going to understand that how do we make sure that our company, our organization is safeguarded from this sanction screening risk. How will we safeguard ourselves from money laundering, financing of terrorism, PEPs risk? So let's discuss that. So in order to make sure that we are secured and our company is managing the targeted financial sanctions risk, the first and foremost suggestion is to have a sanction compliance policy. Sanction compliance policy will talk about what are the sanction lists that we will follow, how will we react, what are the reportings that we will file. Now, there are only two sanctions which are mandatory, but in specific zones in UAE, there are certain other sanction lists also that we need to comply with. So in such cases, we have to make sure that whatever is applicable to us, depending upon under which supervisory authority we come, we have to make sure that we are discussing or mentioning that in our sanction compliance policy. Now, say for example, a company is in mainland. But if you know that you are dealing with many clients who are not locals but from foreign countries, so a risk-based approach is always suggested to, that is, if you know that you're going to deal with European clients, make sure you have certain sanctions list which are applicable there also that are being implemented or that is being followed in your own organization. Also, we need to document the process, that how are we going to comply with the subscription that we do. Like, as I said, we have to subscribe to EOCN website to receive timely updates. Timely updates means wherever there are any changes or updates in the sanction list, that will be sent via an email to us. So what is the process that we will follow when such update mails are received? So that entire process also needs to be documented in your sanction compliance policy. When the sanctions compliance policy is done, The next suggestion is to have a sanction screening solution. So many, as you know, the different companies have different kind of risk appetite, different kind of clientele. So in such cases, we have to first look at what is our requirement and which software will fulfill our requirement. Whether we are looking for some integrated system where it will be integrated with our CRM. Are we looking for that kind of solution? Are we looking for just sanction screening? Are we looking for adverse media? Are we required to go for that? So in the second suggestion, it's important that we identify what kind of screening solution we are looking for, and that would also help us mitigate and suit our organization at the same time. You know, it's just, we should not have a software just for the sake of having. Okay, we have to make sure that it is fulfilling our organization's requirement. So that is selecting the correct sanction screening solution. Once we have done that, we will make sure that the employees which are working in our organization or the one who would be handling the screening work or customer onboarding or KYCs of new, the new customers that we onboard, they are trained with respect to how to use the software, what to do when matches come up, how to negate the matches, if there is any true match, how do you act on it, under what category is coming, what compliance is required. So training is very important with respect to the software that you get on. It's not just very easy to get a software screen and just say that yes, we are doing screening. No, that is not the case. Once you start using a software, or maybe if you're doing it manually also, we must know that what are the implications or what are the steps that we need to take when we find a match. Match could be for sanctions, match could be for adverse media, match could be for PEP, that is politically exposed person. So what action is to be taken? That training is also required for the person who is handling the software or who is handling the entire customer onboarding process. The next is screening. Of course, we get the software, so now we are required to screen also. We have to make sure that the sanction screening app that we are, subscribing to, that covers the mandatory sanction list. That is UNSC consolidated list and UAE local terror lists. Apart from that, it should also cover those sanction lists which are relevant for our organization. If, as I said, there are other supervisory authorities in UAE where they mandate that certain other sanction lists in addition to UAE and UNSC, they have to screen against those sanction lists also. So even that should be covered by the software, and you must follow the law. If they are asking you to screen or screen against a specific, say for example, European Union or UK HMT OFAC sanction list, then we need to do that. Also, some companies can voluntarily also screen against other sanction lists because their business is different, the clientele is different, the clientele might be coming from a specific region. So that compliance is also suggested. And whenever you come across any matches, required TFS compliances, that is filing fund freeze report or partial name match report, as the case may be, should be compliant. And the last is review of sanction compliance data. Review means, let's say that if you have a policy of reviewing your compliance structure or screening every 2 months, just making sure that all of the customers who have onboarded in last 2 months, are they being screened, whether ongoing monitoring is happening or not. So if that kind of review is planned for the organization, it would be very easy that 1 year down the line, when you are required to go through the AML audit, you will have very less observations when it comes to sanction screening compliance. So it's better that we have, it is suggested to have 3 month, 2 month or 1 month, whatever is convenient for the organization, to have a period where you will check your compliance with the sanctions requirement. You do health check. In 2 months, you might come to know that, okay, you missed maybe 1 or 2, or maybe ongoing monitoring is not working as required. So you will have time to remediate that and also make sure that all of the required watch list. So when you go for a software, they generally have a list of watch lists that they're going to cover. So that is also something that must be looked at when you are reviewing your compliance paper. What if you get a software and you are not screening them against UAE local terrorists? What's the point of having it? So you're not compliant basically. So this is the step-by-step process, how you're going to manage the TFS risk, having a sanction policy, making sure that the screening software that you have got is matching your requirement, training the personnel who are going to manage the screening software, making sure that regular health checks are done, just to make sure that in future there's no surprise that you get that okay, we missed something 9 months ago and nobody brought that into the notice. So that is the way how you manage your TFS risk. So far we have covered sanction screenings, okay, UNSC consolidated list, UAE local terrorist list, TFS measures. The next topic that we're going to look at is PEP screening. So who are politically exposed person? PEP stands for politically exposed person. Now, in the definition of PEP, direct family members and close business associates are included. But how do you identify that it's a PEP? If I had to just give you the few characteristics of a politically exposed person is that they would be heading any prominent position first. Second, they would be having that power who would influence the policy making, spending of the funds of the government. So because of that, they have the complete access, right, power, okay, to use government funds. So politically exposed person would generally be any head of the government or any senior politician, uh, retired army officer, senior officer of a political party, senior executive of a government corporation. So these are the positions I would say which would be covered under PEP. So if there's a politically exposed person, he himself is definitely included in the definition of PEP, but his family members, direct family members, that is spouse, children's, close business associates, like the one with whom they have, business arrangements or, partnership business, or they have formed a company, they're doing some business. So even they would be included under the head of close business associates. There are three types of politically exposed persons: domestic PEP, foreign PEP, head of international organization. Domestic PEP is the one who are located in UAE. Foreign PEP would be the one who are located outside UAE. The politically exposed person, like the positions that we discussed, if they belong to any foreign country, they would be considered as a foreign PEP. Head of international organizations means international organizations are those where these organizations are formed. Organizations are formed when two or more countries have come together, signed a treaty, and now they have formed an organization. To give you an example, United Nations, that would be a classic example of head of international organization. If somebody is heading UN, they are head of international organization and they will come under that category. Politically exposed person will always be a natural person. He would be having a prominent public function. He would be having the power to influence or take policy making decisions. They will decide where the money would be used. Generally, politically exposed persons are treated as high risk, but specifically for the domestic PEP, you may take a risk-based approach and decide whether you want to treat them as high risk or medium risk or low risk. So when you are required to conduct enhanced due diligence, there are certain things that you will have to look at. EDD, in EDD, we are required to ask for basic KYC documents. In addition to that, we will also seek for source of fund, source of wealth. Why is that person coming to us and what is their purpose of transaction? Then what was the professional and financial background of that person before he became the PEP and currently? So if you research about that, you will get to know about, some information about that. Adverse media verification. Now, whenever we are onboarding a high risk customer, we need senior management's approval. Once we have onboarded that person, there has to be regular monitoring of that particular customer's profile as well as the transactions that they enter in. Also, we have to make sure that the first payment must come from their own account, which is in their own name basically. So are we ready for the quiz? Request you to please scan and we'll go ahead. Okay. So the correct answer is A and B. Which of the following categories are included in the definition of politically exposed person? It is direct family members and close business associates. So the correct answer is A and B. So 90% of them have answered that correctly. What are the requirements for conducting enhanced due diligence? Okay. So seeking source of fund, source of wealth, senior management's approval before we onboard a high risk customer, and also making sure that the first payment is coming from their account, which is in their own name. So that is the requirement of EDD. So the correct answer is all of the above. Please clap for yourselves. So the last topic today is adverse and social media screening. So social media and adverse media screening, not very much regulatory, emphasis is given to this, but it will help a lot when you are, assigning risk to any specific customer. So if I had to just give you the brief of what adverse media and social media, how that can be done, how that will help you, what is the approach that you should have, let's just briefly discuss that. First of all, we must have their government ID document, ID proof. Once we have that, we can search we can search through the screening software also, because many screening softwares offer adverse media search. You can also go and look out for any independent sources, maybe Google, Bing, you can refer that and you can try to find out if there is any negative media with respect to that person. You can now, if you want to check in the independent sources, there are various keywords or that you can use. Like if you want to do adverse media search about me, so you can simply write Dipali Gora and you can search for words like launder or convict, fines, kickback. So these are these strings which would be available, which you can use, and you will be able to find some relevant articles with the combination of my name and those specific words that you are looking. So that will help you. So once you look at that particular information that you get, articles which pop up with that relevant search, you can refer that and decide what is to be done next. Similarly, when you look out for the social media, now social media means maybe a LinkedIn account, Facebook account, Instagram accounts. You can look at that. You can verify that name and check whether there are any campaign, negative campaign is being started for that person. So that is something that you will come to know with respect to social media search. For example, I have done something wrong. Maybe I'm into business and I have done some illegal work. So maybe some social media has started posting about me that this person is so and so. So you can verify that and understand that whether there is any negative aspect associated with that individual. So once you have done the adverse media and social media verification, you can check out the results. What have you found? And once you're done with that, if you find some relevant adverse media means if you find out that, for example, me, you've got some, articles which suggest that I am into financial crime, criminal activity, or I have done some laundering of funds, or there are various other articles which suggest that I have done some big bank scam or fraud and I'm absconding. So in such cases, it is possible that you should have a risk-based approach and decide whether you want to associate with such a person or not. Also, if that media is not that relevant, but yes, some kind of articles which suggest that it will make me a high risk client for you, you can conduct EDD, do some enhanced due diligence, and then on. After adverse media and social media verification, if you find a result where you did not find anything against me, no adverse media, no negative articles, no negative taggings or hashtags, negative campaign against me, then it is, then it would be more easy, or I would say low and medium risk, you can decide, and then you can establish a medium business relationship without any hassle. So that is how adverse media and social media will help you and also change your risk assessment in a way which will be more beneficial to your organization. And the last is, what is the risk of unaddressed matters? For example, you are screening a person. when you screened them, you got lot of matches, but you have not, given out your comment or verified that with the actual information that you have. So that will also create a risk, because those are false positives, and unnecessarily, lot of updates will be sent to you through the software that there's an update. Please look into that. So it's important when you screen somebody, if you have got 2 or 3 images, you should nullify them or say that the information doesn't match, or the name doesn't match, or the date of birth doesn't match. So that should not be kept open in the software. So here the importance of training is very important, because if a person is just using the software for the sake of using, they will just screen the name and leave it. They will not even look at the results, what is coming. So that should be avoided completely. Then is false negatives. So if you screen somebody and that person was an actual match, and if you ignore that, that will be very risky for you. For example, Mr. ABC. Now, ABC has a lot of adverse media against them. The name is in the sanction list, and you completely ignore that. That will also cause a lot of problem to the organization. That will have compliance risk also, because you are associating with a person who is in the sanction list, which is in the mandatory sanction list. There would be reputational risk for the company, because in future, if something, some articles come up and, some evidences show that your company was associated with that ABC individual, that will hamper your goodwill also. That will have, now when you associate, if you are into, say for example, auditing and accounting business, and you deal with somebody like that, there is a financial crime also associated with that, because your license, that will also be under the question. When you deal with a person who is sanctioned, or there is an adverse media where you had to ideally take action or file STR or file countries report, but you ignore that, that will also lead to regulatory fines and penalties. And when this happens, goodwill is affected. There is a, there would always be a risk of business license being cancelled. So your business is going to suffer. So it is important that when you use a software, if you screen somebody, if you do not find any match, well and good. But if you find any matches, we have to make sure that we are clearing it, giving our comment, whether it is a true positive, whether it's a false positive, what exactly. So that comments should always be there. I hope this session was informative for you, and thank you so much for being patient and listening to us. We will again be back with some more interesting topics, and we'll keep you posted on that.